You were injured in a Florida crash, but there's a problem. You think you may have been partially at fault. Maybe you were speeding. Maybe you didn't see the other vehicle. Maybe you didn't use your turn signal. You made a mistake too. So now you're wondering, can you still recover damages in Florida if you were partly responsible? Yes, you can, but Florida law changed in 2023, and the answer is now much more important than it used to be. Florida follows what's called a modified comparative negligence system. That means fault can be shared between multiple people. A crash or a slip and fall is not always an all or nothing case. A jury can assign percentages of fault to everyone involved. For example, driver A may be 70% of fault. Driver B may be 30% of fault. Under Florida law, damages are then reduced by your percentage of fault. Now, here's the major change I mentioned before. Before 2023, Florida used a pure comparative negligence system. That meant even if you were 90% at fault, you could still recover 10% of your damages. That's no longer the rule in most negligence cases now. In Florida's modified comparative negligence law, if you're found to be more than 51% at fault, you're barred from recovering damages entirely. That changed the landscape of Florida personal injury law. Here's a simple example. Let's say your total damages are $100,000. A jury finds you were 30% at fault. Your recovery would be reduced by 30%. So instead of receiving $100,000, you recover $70,000. But if the jury finds you were 51% at fault, well, under Florida's current law, you recover nothing. Shared fault comes up constantly in Florida crash cases. Examples include speeding, distracted driving, following too closely, failing to yield, lane changes, cyclists not using lights, and pedestrians crossing outside of the crosswalk. Insurance companies look aggressively for anything they can use to shift the fault onto you because every percentage point matters. Now, this is one reason insurance companies focus so heavily on comparative negligence. If they can increase your percentage of fault, they reduce what they offer to pay, or they eliminate the claim entirely if they're going to say that you're 50% or over by denying the claim. That's why adjusters ask detailed questions early. And that's why recorded statements matter. Small facts, seemingly in the beginning, can become major arguments later on. A case that should settle early gets drawn out with the filing of a lawsuit. In comparative negligence cases, evidence becomes everything. That includes crash reports, incident reports, photos and videos, witnesses, vehicle damage, surveillance footage, dash camera footage, event data recorder information, medical documentation. Because the fight is often not whether a crash happened, it's who gets blamed and for what percentage. Now, this issue comes up frequently in bicycle and pedestrian cases. Drivers may argue the cyclist was invisible, the pedestrian crossed improperly, the cyclist came from out of nowhere. But under Florida law, drivers still owe duties of reasonable care, and comparative negligence does not automatically eliminate a claim. The question becomes, how much fault does each side have? One important point, insurance companies do not make the final determination of fault. A jury does. And juries look at the totality of the circumstances. They're going to evaluate credibility, conduct, road conditions, reaction times, visibility, human behavior. Fault allocation is often highly disputed and highly strategic. The real danger in comparative negligence cases is this. People assume partial fault means that they have no case. That's not true. In many Florida injury cases, fault is shared. The legal question is not, were you perfect? The question is, what percentage of responsibility belongs to each person? So, can you still recover damages if you were partially at fault in Florida? Yes, if your percentage of fault does not exceed 50%. And in many cases, determining fault is where the real legal battle begins. I'm George Palaidis, a Florida personal injury attorney. Understanding comparative negligence can make a major difference in protecting the value of your case.